All right, we're back at the Special Committee on Impeachment Inquiry, and we're going to be spending the rest of the morning talking about our use of force standards, policy, and training. And before I turn it over to Legislative Counsel, I will just explain that a few years ago, various incidents around the country really caused us to take a look at use of force here in the legislature. And what we found is that we've given law enforcement authority to use force, including fatal force as well, without putting any standards in place. And this led to a couple years worth of work to put the legislation into place that establishes these standards. And subsequently, policy was put together as well, which we'll hear about a little bit later. But we're going to start with Legislative Counsel's kind of review what we have in legislation. So please proceed.
Good morning. My name is Ben Novogrodsky from the Office of Legislative Counsel. It's good to see many of you again. But to piggyback off of Representative Malone's comments just now, Title 20 of the Vermont Statutes Annotated, Section 2368, is Vermont's standard for law enforcement use of force. This kind of came about over the course of a couple sessions. First, Act 165 of 2020 added Section 2368 and also created a mandate for the Criminal Justice Council to develop a statewide model policy for the use of force. And then Act 27 of 2021 codified Section 2368 in its current form. So at the outset, it's important to keep in mind that Section 2368 is located in the portion of our law that governs the Vermont Criminal Justice Council and law enforcement generally. It sets out a standard for how law enforcement can lawfully use force in policing, which in general outlines that the use of force by law enforcement is lawful if it is objectively reasonable, necessary, and proportional, and that the use of deadly force is lawful if it is necessary in defense of human life. For the purposes today, I'll focus on just the general use of force rather than the deadly use of force. So turning to the statute itself, subsection A outlines the definitions applicable to the statute. In the context of use of force, the definitions of force itself and totality of the circumstances are used. So force means the physical coercion employed by a law enforcement officer to compel a person's compliance with the officer's instructions. A law enforcement officer has the same meaning as in 2351A of the subsection. That's essentially all law enforcement in the state in its various forms: sheriffs, municipal law enforcement officers, DPS, so on and so forth. And then the totality of circumstances terminology, which I'll get into a bit more later, means the conduct and decisions of the law enforcement officer leading up to the use of force and all the facts known to the law enforcement officer at the time, including the conduct of the person or persons involved. So what does that actually mean in practice? Subsection A outlines the use of force policy itself in which those terms are used. Or subsection B rather. Subdivision 1 explains that the decision to use force is an objectively reasonable standard that is evaluated from the perspective of a reasonable officer in the same situation based on the totality of circumstances. It further explains that a failure to use reasonable alternatives to force is a consideration for whether the use of force was objectively reasonable. So taking a step back, what is this objective standard exactly, and what does it mean to evaluate from the perspective of a reasonable police officer in the same situation? Both the Vermont Supreme Court and the U.S. Supreme Court have discussed this, not necessarily in the context of this statute since it's so new, but in past cases where use of force has been used. So the objective standard is a determination of whether the officer's actions are objectively reasonable in light of the facts and circumstances confronting the officer, without regard for any underlying intent or motivation. So put another way, an officer's purported evil intentions will not create a violation out of an objectively reasonable use of force, nor will an officer's good intentions make objectively unreasonable use of force proper. The reasonable officer perspective That means that the use of force must essentially be judged real time from the officer's perspective and not through 2020 hindsight. The U.S. Supreme Court has explained that not every push or shove, even if it may later seem unnecessary in the peace of a judge's chambers, is a violation. The calculus of reasonableness must embody allowance for the fact that police officers are often forced to make split-second judgments in certain circumstances that are tense, uncertain, and rapidly evolving about the amount of force that is necessary in a particular situation. That's from the Graham v. Connor case. That was from 1989, I believe. So it's been some time, but this is how long it's been talked about. So moving on to the statute, or moving back to the statute itself. Subdivision 2 really provides the meat of the use of force standard, explaining that an officer shall only use force that is objectively reasonable, necessary, and proportional to effect an arrest, to prevent escape, to overcome resistance of a person the officer has reasonable cause to believe has committed a crime, or to achieve any other lawful law enforcement objective. Subdivision 3 explains that the authority to use physical force is a serious responsibility that shall be exercised judiciously and respect for human rights and dignity for the sanctity of every human life. Every person has the right to be free from excessive use of force by officers acting under authority of the state. Subdivision 4 outlines the decision by an officer to use force, and that it shall be evaluated carefully and thoroughly in a manner that reflects the gravity of the authority and the serious consequences of the use of force by law enforcement officers in order to ensure that officers use force consistent with law and agency policies. So right there you have a mention of agency policies. There's a statewide policy, and my understanding is that oftentimes law enforcement agencies themselves may have additional policies, but the statewide policy that the Criminal Justice Council has is the baseline in addition to this statute. Subdivision 5 states that when an officer knows that a subject's conduct is the result of a medical condition, mental impairment, developmental disability, physical limitation, language barriers, drug or alcohol impairment, or another factor beyond the subject's control, the officers take that into account in determining the amount of force appropriate to use on the subject, if any. Moving on to subdivision 6, a law enforcement officer who makes or attempts to make an arrest need not retreat or desist from his or her efforts by reason of the resistance or threatened resistance of the person being arrested. An officer shall not be deemed an aggressor or lose the right to self-defense by the use of proportional force if necessary in compliance with subdivision 2 to effect an arrest or to prevent escape or to overcome resistance. So for purposes of this subdivision, retreat does not mean a tactical repositioning or other de-escalation tactics. So essentially what that means is if an officer is holding someone down with their hand, but needs to readjust and maybe hold them down with another part of their body, that's not considered a retreat. That's a tactical repositioning. And then finally, subdivision 7 means a law enforcement officer has a duty to intervene when the officer observes another officer using a chokehold on a person. And that was another underlying rationale when these laws were made, was the chokehold and really shoring up the state's standards on chokehold. So I can go into subsection C, which is the use of deadly force, but I leave that up to.
I think that part is necessary. I did have a question. I just wanted to just highlight, make sure it's clear. When you talked about retreat, you did mention the tactical repositioning, but there's also or other de-escalation tactics to kind of emphasize that law enforcement, if there's an opportunity to de-escalate, that's not considered retreat, and it, that's something that's been encouraged, I think. And I will hear more about that in the policy discussion as well. So are there questions for legislative counsel? Yes.
So McCarthy. How does this, how did Act 27 fit into enforcement? So who decides what's reasonable?
Well, That's a good question. I mean, and I kind of started with when I was laying it out at the outset, that this is really about the council itself. These are sort of council and law enforcement standards that, I would envision they are the primary enforcer of these provisions. Now, it's possible that, let's say, allegedly a police officer, engages in something, they could be brought up in criminal court on assault charges, but this isn't necessarily something that would be used in that case. There may also be a civil suit through, potentially like an Article 11. Article 11 is the state constitution's equivalent to the Fourth Amendment. So there could be a direct right of action that's levied against a police officer under Article 11. This could potentially be used in that, but it wouldn't be determinative of, there are a lot of other factors that are involved. So it's a very long way of saying the primary enforcer, as I understand it, is the council and the agencies themselves.
So the idea, I just want to make sure that my understanding is clear, is that this lays out what the policy that the Criminal Justice Council has to do for standards. The Criminal Justice Council adopts model policy that then needs to be adopted by all of the many law enforcement agencies. I think we have several dozen law enforcement agencies in the state, from the state police on down to municipals. And the way that a complaint that was brought saying that an officer had not used reasonable force, this would inform the Criminal Justice Council's deliberation to either sanction or decertify that officer.
Yes.
And Representative Brandon.
Well, just a question, it's a dumb question too. So by municipal police force, you're talking about, for example, the town of Swanton has a police force. The town of Georgia, where I live, we don't. We contract with the sheriff, but we have a town constable.
Mm-hmm.
Are you talking about the constable?
Constable, if he or she is exercising law enforcement authority. So there is sort of a certification that most constables have to go through. But the short answer would be yes, if they met that qualification.
Okay, thanks.
Yeah.
You might have been going to say this, Mr. Chairman. I think it's worth, because we all have different policy backgrounds we're bringing to the special committee, just getting it out there that there is only one law enforcement certification entity in Vermont. The Criminal Justice Council certifies all law enforcement officers, regardless of what agency they work for. Correct.
Yeah, and I'll explain that. Yes, this is primarily enforcement through the Criminal Justice Council, but it is also laying out standards. And I know you are expert in qualified immunity. We're not going to go down that road right now, but the idea as well is to have clear standards, and that does play a part in whether qualified immunity applies or not. But that's not the focus here. So, any other questions? Yeah, Representative.
I just want to summarize, make sure I'm getting it correct. So this is true for all law enforcement officials, but not all folks who are, I don't know what the word for it is, in police roles or whatever, are law enforcement. Like, that's a certification that you get. So a constable would have to get a law enforcement certification. A sheriff needs to get a law enforcement, police officer, right? Is that correct? So there's all these different positions, but whether they're law enforcement certified is not necessarily guaranteed.
And there are multiple levels of certification.
And this policy is needed regardless of the level of certification. You need to follow this.
Yes.
Okay.
So, and just to follow up on that, it's fair to say that it's the certification that provides actually the state's authority for an individual as a law enforcement officer to use force.
Correct, but it also provides the authority to rescind that that respective authority for the police officer.
Right. Appreciate it. Thank you very much. All right, we're going to move to Kim McManus, the Associate General Counsel to the Vermont Criminal Justice Council, and talk about the policy that was a follow-on to the standards that were set for legislation. Thank you for being here.
Thank you for having me.
If you could just introduce yourself for the record, and then we'll proceed.
My name is Kim McManus. I'm the Associate General Counsel for the Vermont Criminal Justice Council.
So, and real quickly, the policy has been posted to our legislative site if folks want to see what that actual policy looks like.
Excellent. And I will be referencing to specific pieces in the policy. So if it's helpful to have that pulled up, or just as I'm going along, you can note the reference and look at it later. I know it's hard to listen and read at the same time. At least that's hard for me. So what I prepared for today for you all is three things. I'm going to review the creation of the policy. I'm going to do a brief overview on the policy. I will not read it line by line. We would be here for most of the day, and you don't need me to read it to you. And then just how the policy was rolled out to the agencies around the state and the council's connection to the policy in that rollout and the compliance that agencies adopted the policy. And please, as I go along, interrupt me as you need. I did write down my comments so that I didn't go too far afield. I know you asked us to do an introduction today, so I was trying hard not to go too deep into the weeds and to allow your questions to take me where you want me to go.
Great, thank you.
Please interrupt if I don't look up to see that you need me. All right, so to back up a bit, Governor Scott issued an executive order number 03-20 on August 20th, 2020. The purpose of the order was to, within the power of the executive branch, accelerate the modernization of public safety operations throughout Vermont. Within this order, Governor Scott set numerous short-term goals, one of which included the development of a statewide use of force policy to be drafted by the Commissioner of the Department of Public Safety in consultation with the Executive Director of Racial Equity, community representatives, and other interested parties for the consideration of, and in due course, the adoption of, a statewide use of force policy by the Criminal Justice Council, which used to be known as the Criminal Justice Training Council. The Commissioner of the Department of Public Safety worked closely with the Council's certified use of force instructors, various interested state agencies, and community stakeholders to develop the use of force policy. The Commissioner wrote a cover letter when he sent to the Governor the finalized draft. This was in July of 2021. And if anyone is interested in the development of the policy, all the steps that the Commissioner took with the interested stakeholders, that memo is a really helpful history of that. It goes line by line through the drafts and then where those drafts were circulated, who had feedback, how they captured that feedback. So that's a memo from July of 2021, and I'm happy to forward that if you need me to. The policy went into effect on October 1st, 2021. As the Legislative Council stated, this policy work and the legislative changes that Legislative Council reviewed were occurring hand in hand. This is also reflected in the Commissioner's memo that I just mentioned. And as you review the policy, you'll see a number of footnotes where legislative language is footnoted, showing that what you see in the standards in the statute is the exact same language that you see in the policy, so that the two are working in concert with each other. As a room full of legislators, you know that law is a set of rules and regulations that are enforced by a governing authority. Policy is not law. Policy is a set of guidelines or rules that are established by an organization, government, or institution to govern its actions and decisions. Policies are typically created to achieve specific goals and objectives and are designed to ensure consistency and fairness in decision-making processes. Policy tells us how we want organizations to follow the laws. So we have the standards set out in the statute, and then the statewide policy gives us the how. How are you going to do this? How are you going to meet these standards? The creation of the statewide use of force policy created clear and consistent guidance for law enforcement in the state. Prior to the statewide policy, almost all agencies in the state had their own use of force policies, which were aligned with state and federal law, but were not consistent across the state in the depth of explanation and guidance given to the officers in how to interpret state and federal law concerning the use of force when necessary. A number of agencies within Vermont had rather robust policies prior to the statewide policy, and these documents, coupled with guidance documents from outside the state, informed the creation of the statewide policy. And you can see that reflected in the reference page, which is page 16 in the policy. As previously stated, and as you all know, again, policy is not law. This policy, as stated in its introduction, is a guide and shall not be construed as creating any substantive or procedural rights enforceable at law by any party in any civil, criminal, or administrative matter. However, the policy and any violation of the policy can be used for internal agency proceedings, meaning an agency's disciplinary or employment matters, and for proceedings with the Criminal Justice Council, which would be a certification matter. Any questions on the creation of the policy? Wonderful. Okay, overview of the policy. The copy that was forwarded to you says at the top, effective as of April 2023. As I just stated earlier, the original policy was effective October 1, 2021. In April of this year, there was a small amendment to the policy, and this was regarding a clarification to the terms protective custody and temporary custody. This is in Appendix D, which has to do with when police interact with persons with who are known or perceived to be having a mental impairment. This amendment, which occurred in April, I'm happy to go into it further, but it doesn't impact the main body of the policy as it was effective in 2021. So I can happily go into that, but I just wanted to explain why it says April of this year at the top of the document. Okay. The main takeaway of the policy, and as you're reviewing the policy on your own, I would suggest writing down the following sentence on a little sticky note as you read through every section. And that is the second sentence to the policy statement, which is at the bottom of page 1. When force is necessary to bring an event or incident under control, officers will use only objectively reasonable force to accomplish lawful objectives. This one sentence is the touchstone of the entire policy. This sentence is what the remaining 32 pages of the policy, including the appendices, fleshes out for officers and for their supervisors. As a policy, the policy outlines the best practices and the expectations of the state of Vermont and the Criminal Justice Council for its law enforcement officers for when and how and why they use force. Legislative Council read a few of the definitions, and I don't mean to be redundant, but I think it's helpful to go through that one sentence together, if that's okay with the group. Okay. Okay, so taking that sentence, the first piece, so when force is necessary. Force is defined within the policy as physical coercion employed by a law enforcement officer to compel a person's compliance with the officer's instructions. For the purpose of this policy, this includes all law enforcement actions beyond compliant handcuffing. And that means anything beyond someone will, on their own, putting their hands together to be handcuffed. The moment, and Sergeant Ackerlin can correct me if I say anything wrong as to actual techniques, but any touch beyond that would be considered force for this policy. So when force, we define force is necessary. Necessary is defined as when a reasonable officer with the same information and in the same situation would conclude that no reasonably effective alternative appears to exist. So we have when force is necessary to bring an event or incident under control. I can allow Sergeant Ackerlin to go into various events and incidents if the committee would like. But the next piece is when under control, officers will use only objectively reasonable, and again back to force, but objectively reasonable. In the definition, it's a little bit long, but I think it's important to read through it. Whether the decision, and again, you'll hear language again that Legislative Council had said earlier, whether the decision by a law enforcement officer to use force was objectively reasonable shall be evaluated from the perspective of a reasonable officer in the same situation based on the totality of the circumstances. A law enforcement officer's failure to use feasible and reasonable alternatives to force shall be a consideration for whether its use was objectively reasonable. The calculus of reasonableness must allow for the fact that police officers are often forced to make split-second decisions about the amount of force that is necessary in a particular situation, in circumstances that are tense, uncertain, dynamic, and rapidly evolving. The definition then goes on, and again, this gets into how the policy fleshes out the how for the standards listed in the statute. The definition goes on to list the following factors to be considered in determining the objective reasonableness of force, include but are not limited to. So a few factors for the officer to be thinking of when interacting with a person. The seriousness of the crime or suspected offense, the level of threat or resistance presented by the subject or subjects, as in proximity to weapons, potential for escape, availability of other resources or officers, meaning availability of other resources or officers to then not have to use use of force or to change the amount of use of force needed. Whether the subject was posing an immediate threat to officers or a danger to the community, and then the potential for injury to citizens, officers, or subjects. The last part of that sentence reads to accomplish lawful objectives. Lawful objectives is not defined in the definitions, but if you look under section 2, considerations prior to force being used on page 5, the policy provides the following guidance regarding lawful objectives. And again, you'll hear echoes of the statute in this language. Use of force is intended only to control behaviors and situations while accomplishing a lawful purpose. It is never intended to be punitive. Officers must constantly reassess the totality of the circumstances in any encounter where force is necessary to gain compliance from an individual. A law enforcement officer shall use only the force objectively reasonable, necessary, and proportional to effect an arrest to prevent escape or to overcome resistance of a person the officer has reasonable cause to believe has committed a crime or to achieve any other lawful enforcement objective. Whenever feasible, officers shall allow individuals reasonable time to submit to arrest or detention before force is used. And then, I won't read it out loud to you, but the word proportional, which was in that guidance, which is in the statute, is then defined in the policy as well. Now, if we go back to the policy statement, there's 2 sentences. The second sentence is the one that I said is the touchstone, that as you're reading through the document on your own time, you can keep coming back to how the document is offering the officer's guidance to think through that sentence. The first sentence is important to note is the how and why of the policy. The first sentence is, this agency believes in the sanctity of human life and in the value of de-escalation and effective communication. Throughout the policy, you will see continued emphasis on de-escalation and effective communication.
Can I just ask, when it says this agency, who is the agency?
Thank you. I had a note in my mind. So what's important to remember is that this policy was written and sent out to agencies so that the agencies could adopt this policy in whole. So I'm going to mention it. I'll probably repeat myself at the end because of my notes, but this was sent out to agencies as a Word document. And the expectation was that it would be copied as this agency. So this town of, city of, whatever agency, that this is now this agency.
St. Albans Police Department, Franklin County Sheriff.
Exactly. All right. So like when it's in their policy and procedure manual, it's that agency speaking when you hear this agency. The emphasis for de-escalation and effective communication, again, as you're reading through, you'll see a heavy emphasis on this. And this is you speak to law enforcement before all of this started to take place, the statute and the policy. If officers can avoid use of force, that is always the goal. They try to do anything they can beforehand to not have to use of force. And that's where de-escalation and effective communication come in. You will hear Sergeant Ackerland speak to this very eloquently, that de-escalation has to do with not only just de-escalating the subject if they're elevated, but also an officer being aware of where they are at and de-escalating themselves to make sure that they're not adding into the situation, not causing the need for use of force by their own behavior. I won't read it out loud to you, but on page 5, just to point out, again, just to highlight where the committee may want to look further. On page 5, there are 2 paragraphs there that discuss when possible, and it is a shall from the policy. When possible, officers shall use de-escalation tactics. And it goes through again the why, and then it lists out some of the hows in there. And this again all informs the training that comes out from the council. You will see another note at the end of page 6, which is section 3, less lethal force, so meaning not lethal force. I will read this just for a moment. When an officer meets resistance in the performance of lawful duties, reasonable attempts to inform the subject of the reason the officer is taking relevant action should be made. To the extent feasible, persuasion and de-escalation should be used, and officers should take reasonable steps to provide accessible, effective communication. As you work your way through the document, on the second page, there is a table of contents. I'm just going to point out a few things again to note, but I'm not going to go line by line so that you're not seeing it fly behind me there. But the less than lethal force is from pages 6 to 10. This section outlines the factors that an officer needs to consider prior to using force, factors to consider when considering what level of force to use, and a discussion on use of force techniques. Less than lethal force is then followed by a section on lethal force, pages 10 to 12, which details when lethal force is authorized and when it is restricted. Rounding out the rest of the policy, the policy provides for an affirmative duty for an officer to intervene when witnessing another officer using a chokehold or excessive force. This can be found in section 5, page 12. This duty includes a requirement that an officer report any instance of excessive force or chokehold to a supervisor prior to the end of their shift. Section 6 goes on to outline the officer's duty of care, that an officer must provide or timely summon or obtain appropriate medical attention for a person in their care or custody who is injured, whether use of force is used or not. When an officer uses force beyond compliant handcuffing, the officer must complete a use of force report. A blank copy of that report is in Appendix C. This duty is under section 7, pages 13 to 14. And the section outlines the reporting requirement of the officer involved and the supervisory review of that report. The supervisor needs to determine whether the use of force, was objectively reasonable and whether it was consistent with policy. If after that review, the agency head finds that excessive use of force was utilized, that the force violated this policy, the agency head must refer that matter to the Vermont Criminal Justice Council. The agency head is also required to report to the appropriate authorities if the report and review of that report, if the report and a review of the incident uncovers evidence that a crime potentially was committed. The agency head has a duty to report that. If lethal force is employed or an action is taken that results in death or seriously bodily injury, the agency must conduct an administrative investigation as explained in Section 8, page 14. Lastly, Section 9 of the policy outlines the training requirements the use of force policy requires. And again, Sergeant Ackerland, who will follow me, will speak in detail about the use of force training in a few moments. The important pieces of the policy that I would highlight for you today in relation to training are the following. Officers must comply with the Vermont Criminal Justice Council certification and annual in-service training standards. The Vermont Criminal Justice Council requires that officers take 4 hours of use of force instruction on an annual basis. The council, this has been a requirement with the council since 2018, predating this policy. But it is a continued mandated requirement of 4 hours per year. And then directly from the policy, and this is, I'll give you a page number. Sorry, I did not write it down. Page 14, and then moving on to page 15. For the purpose of annual certification, so for those 4 hours of required training, only use of force and tactics training conducted by instructors certified by the Vermont Criminal Justice Council is acceptable. It goes on to, the policy goes on to say, all officers will receive a copy of and training on use of force policies at least annually, and all training will be documented. In addition, all officers shall be trained on ways to avoid confrontations, de-escalate conflict, and recognize during a physical confrontation when de-escalation must occur. Regarding other types of training, anything outside of what the council would train, the policy says, if an agency considers sending officers to additional use of force or tactics training, the CEO, the head of the agency, should carefully review the content and philosophy of the training to ensure that it is consistent with Vermont law and this policy. Agencies are cautioned that standards for police use of force vary widely across the country, and considerable scrutiny should be given to other trainings. Material from outside resources may not be introduced into the use of force training curricula for Vermont law enforcement officers unless the additional content has been reviewed by the Vermont Criminal Justice Council Use of Force Committee and approved by the Criminal Justice Council. Per the policy, the Criminal Justice Council began to roll out training to the policy in August of 2021, after the policy had been sent to the governor by the Commissioner of the Department of Public Safety. Training continued throughout the summer and fall, so that when the policy went into effect on October 1, 2021, law enforcement officers across the state were trained to the new policy. When the Commissioner of the Department of Public Safety sent his memo and the attached finalized policy draft to the governor in July of 2021, this same memo and the finalized draft of the policy was sent to all agencies across the state. And within that memo, it directed, and I'll use the language so that I don't misquote, this is the former commissioner at this point. In the commissioner's memo, it states instructions to Vermont law enforcement agency heads. This policy and its appendices are intended to be adopted in their entirety. All agency heads will receive a copy of this policy in Microsoft Word format so that it may be copied into the agency's format. The council staff, so this was all sent to agencies July of 2021. The policy went into effect October 1st, 2021. Council staff reached out to all of the agencies across the state, to affirm that the agencies had adopted the statewide policy. And in December of 2021, the Vermont Criminal Justice Council sent a memo to the commissioner with a list of agencies who had adopted the policy. And it was across the board, all of the municipalities and Vermont State Police, all agencies across the state had adopted the policy. So that was confirmed by December of 2021. The compliance from then after, agency heads are required on an annual basis to report annual in-service training to the council. Within that report is also attestation that the agency continues to comply with the statewide use of force policy.
Representative Dolan.
Thank you for this overview. This is really great to have. It seems very comprehensive, and the fact that it's working together with legislation and policy together is very helpful. And for me, and pulling these pieces together, it seems like all the information is there as far as the policy. A key piece of it, though, seems like is on the supervisory review piece, because an incident happens, it's a supervisor that's going to review it to determine if it was an excessive use of force and should go to the training council or not. And so a couple questions on that. I don't see, does the supervisor that's reviewing this have to be a certified law enforcement officer?
That's an interesting question. If the supervisor is performing law enforcement duties, they need to be certified.
But to review
And it can be potentially corrected by Deputy Director Burkell this afternoon. And so I will make a note to make sure he follows up. The only supervisor in an agency that potentially would not be certified would be a sheriff. That's an elected position. So technically, you don't need to be certified. But in any other capacity, I'm trying to think of an instance when a supervisor would not be a certified law enforcement officer, and I can't think of an instance of that.
Okay. Because I'm thinking that's an important detail is a law enforcement certified supervisor, because it seems like understanding and interpreting this policy is critical in determining if use of force is excessive or in violation of things. And so I just think that somebody isn't understanding that it is, could be saying, no, this is fine, or this isn't fine, but they don't have that understanding. So was that discussed at all? I just feel like that's an important piece.
It is, and if you read through that section for the supervisory piece, again, that's a duty of the supervisor to do that review and to do it well. If somebody is not doing that, they are then potentially in violation of the policy. And again, that violation could come before the council. One thing I will note, which may be a follow-up question, so I apologize if I'm jumping ahead. If, say there's a scenario where something happens and a supervisor is like, no big deal. That's not the only road that a complaint can come to the council. So it can come from another person could have seen something, could make a complaint, and Deputy Burkell is going to speak to this later about the council's ability to investigate a use of force complaint separately.
Okay. And that was part of a follow-up. I'm also wondering if the council does any, and I know this is kind of new, but does any auditing of departments to see, like, oh, let's see what your excessive use of force complaints were, and let's see, pick some of them to see, what did you make a decision on? Would we have made the same decision? Is there any of that auditing that's happening?
So the audit piece, I cannot speak fully to, in that we have for officer, it's annual certification, what training they take, that we can audit. And that is something that is relatively new to the council to go out and say, can we look specifically at your records? And again, Sergeant Ackerland may be able to help me out when he comes up, and because I don't want to flip and try to read it on the spot. Well, I do know for deadly lethal force or force that leads to death or serious bodily injury, those use of force reports need to be reported. And I just can't think of what authority right at the moment.
Okay.
But I can follow up on that for you.
Okay, but that's specifically for,
That is specifically for deadly force.
thank you.
So a follow-up question to that. So the use of force report, is that, does that just go to the supervisor then? That there's not a requirement that that also be sent to the council?
I do not believe it's a requirement that we receive that a use of force report unless the supervisor finds that it is excessive use of force. And I know this is part of Sergeant Ackerland's presentation of what that supervisor, it goes through more than one supervisor sometimes. So we can speak to that, of how that review process occurs.
And I assume, but I'll ask a question anyway, but that you don't have an idea of how many use of force reports different agencies have compiled, whether they come out and say that was fine or not fine. I mean, presumably the ones that it's excessive, you hear about those.
Correct. Yes, that's it. I do not personally know that data. I can see whether that data is collected in any way. I don't know off the top of my head that it is, but I can follow up with the committee for that.
Any other questions? Yeah, Representative Carthy.
Thanks so much for going over that with us. I just wanted to know, is there anything in the Criminal Justice Council's policies that prioritize the complaint? So for instance, if they receive a complaint and do an investigation, is there anything that says they have to take them in a certain priority, or, that a particular excessive use of force complaint, rises higher and they have to act on that more quickly? Or is there anything that the Criminal Justice Council is obligated to do in terms of the timely response to the complaints?
There's nothing written in our rules and policies as far as how to sequence that. I would say there is a practical application that if there's a safety concern, that would rise, go through the paces of our work. If often when we'll use of force complaints, but other professional conduct complaints, if we receive that complaint, often officers are suspended in some way by their agency. And so that then takes down safety concern that they're not operating in a law enforcement capacity while they're in the queue for us to look at the complaint. So that gets factored in. And I won't go too deep into this because again, this is this afternoon, but Conduct A complaints are criminal matters, Conduct B is policy matters, and Conduct C, Category C, I should say, are council violations. So if we were to prioritize, Category A would often bump up, but usually again, because there may be a safety concern. But there's no specific set criteria for ordering.
Thanks.
Well, thank you very much, Council McManus. I really appreciate your time and the information. It's been very helpful. And we'll turn to Sergeant Ackerland. Did I say it right? Excellent, thank you. If you could introduce yourself for the record and proceed.
Thank you. Morning, everybody. My name is Mike Ackerland. I'm currently employed by the Colchester Police Department. I work in our detectives unit as a sergeant there now. I'll give you a quick introduction of just my background so you understand why I'm the guy that's sitting in front of you today. I've been a full-time police officer in Vermont since 1997. I've been employed by the Colchester Police Department since the end of 1998, where I've remained for my career. Around 2000, I took my first use of force instructor school through the police academy with various instructors there, and became an agency trainer then for my department. As I worked up through my time and my ranks there, I was assisting with instruction at the full-time basic class at the Vermont Police Academy with different instructors. Around 2011, I was invited to continue that work at the police academy and become unofficially adjunct faculty down there, teaching in that basic recruit class function down there and providing instruction to all the full-time classes that come through. Became an instructor trainer about a year later with that program and started assisting in our instructor level classes that we provide in the state to teach other agency trainers and continuing on with that basic class function there. In 2017, I became a master instructor through our agency and through our home training agency, which is an outside agency that is the foundation of our program, and continued on with that. Around 2015, I became a member of the Use of Force subcommittee at the Police Academy and currently sit as the chair of that committee. I've held the vice chair position and now the chair position. Also an instructor for our firearms and lethal force program, taser instructor, impact munitions instructor, and a variety of other things with my agency there. But that's why I'm here today. So when we talk about police use of force training, yes, 2020 was kind of the pinnacle change moment for a lot of law enforcement training in the state and around the nation with the things that were going on. But prior to that, Vermont had already started down that road of determining what kind of training we wanted our police officers to have through the Vermont Criminal Justice Council. I'll shorten that to VCJC as I refer to them. It's less mouthful. In 2018, the VCJC, from testimony from our use of force subcommittee and our instructors, mandated, in addition to all the other training that is part of our Rule 13 annual training, they mandated that officers receive 4 hours of use of force and tactics training every year. Prior to that, there was no mandate, there was no requirement for use of force training. An officer could, in theory, attend the police academy and never again receive any follow-up training or continued training in use of force and tactics, which was kind of terrifying to us as instructors. So we decided to push for that change and try to get that on the books so that agencies have to do that. Most agencies out there were doing that on their own anyway, realizing the value of that training and understanding that this was a high liability area for their officers and something that we do frequently as part of our job. So there wasn't a huge lift for everybody, and we got that on the books. Around 2020, that's when things started to change for us, and that's when the talk of this statewide policy really came into place. Prior to that, there wasn't very much legislation at all that controlled use of force training or police use of force in general. Prior to 2020, we did have a policy, model policy issued out by the legislature for the use of CEWs, conducted energy weapons, otherwise known as tasers, that everybody's using, and that became a model policy that if an agency was adopting those weapons, that they had to adopt that policy as the foundational policy. Really nothing else existed on the books prior to that. Even when that policy came out, as council spoke to before in 2021, that policy finally rolled out, and we were able to get that out to people and get it issued into their agencies. It wasn't a huge change operationally for most agencies that were out there. A lot of that comes back to, as we spoke before, there's one certifying agency in the state of Vermont, the Vermont Criminal Justice Council. There's one police academy that everybody goes to, whether you're a state trooper, a Colchester police officer, a Chittenden County sheriff, or a town constable. If you're getting law enforcement training in Vermont, you're getting it at the Vermont Police Academy through the Vermont Criminal Justice Council, period. So because of that, and because of having that single training source and that single certifying body, we were able to standardize what was out there and what police officers were doing. And we couldn't mandate what agencies were allowing once those officers escaped the police academy and went back to where they were. But at least the base foundational training that they were getting and that information they were getting was consistent and was the same. And I think that definitely benefited us when this policy rolled out, because a lot of the policy came from the training that we were already doing and that we were already on the books and everybody was on the same kind of level coming out of the academy there. In 2021, that policy was issued July 1st, and between July and October of 2021, I was one of the people that was selected to help with a rollout of this policy, and we held several sessions around the state. We'll call them end user trainings that we would do 2 or 4 hour blocks of training just to roll out the policy and explain it to officers, troopers, deputies, people in the field that were doing the work and getting that information to making sure they had the consistent message and the policy was consistent there. We also did a series of trainings afterwards, which we would call supervisor or administrator trainings that were for agency supervisors, agency heads, anybody in an administrative function in that agency, where we go a little deeper into that policy, specifically into the review part of that policy, reporting part of that policy back to the agency, back to the council for violations, things like that. And we rolled out a series of those trainings as well, so that in October of 2021, when that policy was put in place and everybody was there, they at least, again, had that consistent message and that consistent training that everybody was on a level playing field there. Big things in that policy, the big buzzwords that came out of that we all heard about were de-escalation and duty to intervene, a ban on chokeholds and all those things. While that language may have been new, or we may have been calling it something specific now, that was still consistent with the way we had been training police officers for a very long time in the state of Vermont. The de-escalation tactics were something that we taught. We may not have branded it with that specific name, but we talked about making sure people have a chance to comply with commands when officers are issuing verbal orders to somebody, using tactics to prevent furthering an injury or increasing and agitating a scenario or a situation that we were in. So it was training that we were already giving our officers. It was just now a little more labeled or compartmentalized, and we could point to it and say, this is our de-escalation training, and this is what we do. Duty to intervene was the same way. While the legislation, the legislative intent may have been specifically to chokeholds and the officer's duty to intervene when we saw that, it was a duty to intervene anytime we saw something wrong or something that we could help with. Intervene didn't necessarily mean stopping a police officer from what they were doing, but it could mean helping in a situation so that that lower level of force could be attained with multiple officers controlling somebody versus one officer controlling somebody. So that was really where that came out of. The ban on chokeholds has always been taught the same way. Chokeholds or neck restraints, however we want to call them. In Vermont, when we were allowed to train those, we only ever trained those at a lethal force level as a last resort technique. Deadly force was authorized, and that was something that the only exception to any sort of neck restraint technique. We did not use them for any sort of control tactic or control technique as may be allowed in other parts of the country or other places in the world. Chokeholds and neck restraints were always only a lethal force option in Vermont, similar to how they sit now in legislation and in policy. Like I said, for most agencies, when this policy really settled out and then we got over the initial shock and awe of everything, most agencies looked at it and realized that this pretty closely matched what they already had on the books. And it was a matter of taking that policy, putting their name on top of it and adjusting it, with that same foundational policy, adding in the other things that they needed going from there. So that was really where the policy and everything came from. When we talk about training, one of the biggest things we talk about in training at the police academy, I like to tell people the physical techniques and tactics are the easy part. I can take a group of students into a gym, and with enough time and enough repetitions and enough space on the mat, I can teach anybody to do the physical tactics. The difficult part or the harder part is the when and why of how we use force, right? Or the how and when we use force. When are we justified to use force? What kind of force are we allowed to use? Why do we use force to begin with? So that's really where I'll focus some of this, right? So why do police use force? Very generally speaking, right? Is to facilitate control. And I think Legislative Council and Attorney McManus has already talked about that, is to control something, control a person, control a situation, control an incident. However we're using that force, whatever force we're using, is just to facilitate control of that scenario. It may look like that control may be to defend somebody else, to defend ourselves, to stop somebody from harming themselves. But that's really what it is. It is to control something. So that's why we're using that control. Just like it's already been talked about, it has to be for a lawful objective. officers are using force in some lawful objective. We're governed by the legislation, we're governed by our laws. I'm either taking somebody into custody for a crime, taking them into custody for protective custody or temporary custody, or I'm stopping them from doing a bad act that may happen later on. That's it. Never going to be used in a punitive manner. It can't ever be used as anything like that. And then we get to that standard. The Legislative Council talked about that objective reasonableness standard. Any force that is ever used by an officer has to be deemed to be objectively reasonable. In the policy, it talks about reasonable, necessary, and proportional. And those are the things. Was that force reasonable at the time based on what the officer knew? Was it necessary? Was that officer at a situation where he needed to be involved to begin with and use force to control that situation? And then proportional. And proportional, it can be an interesting term for people if we're not sure what that means. When we use force, it's never a 50-50 kind of meet them at the nose type of thing. If somebody is resisting at a certain level, I can't meet that with the same level of force and be able to overcome that resistance. I have to be slightly above it, proportionally above it. Again, that's where we draw that fine line between what's reasonable and what's not. But we have to be able to overcome that resistance, overcome whatever action they're doing in order to stop them, to get them into custody, whether they're trying to escape, whether they're trying to assault the police officer or somebody else. That force is proportional in there. But again, it's not going to be an even match to that resistance or that force that we're meeting from that subject. So that's what that proportional language really speaks to, and that's how we train it to our new officers. That Graham versus Connor case in 1989, Supreme Court case there, that is what gave us that objectively reasonableness stand. That's been challenged several times since then, and Supreme Courts and state courts across the country have deemed that is still a good standard, and that's what we want to see. 1993 was a case in Vermont, Cole versus Johnson in the city of Rutland, involving a Rutland City police officer and a use of force issue down there. And that was really where the Vermont Supreme Court first looked at that case and said, yes, this is a good standard as well, and we like the standard. We're going to adopt that in Vermont. That was back in 1993. So here we are 30 years later, still looking at that same standard, and courts are still agreeing that, yes, this is when it's appropriate and when this is used the way it should be, this is a good standard. This is where we want to be. This is how we want to judge our officers' actions and how they use force.
Can I just interrupt?
Absolutely.
A question on the objectively reasonable. How much does the policy and the standards lay out what is objectively reasonable?
So we talk about it and we can't get into specifics. It would be impossible to try to get specifics on every single encounter a police officer might get into, every single point that he gets into. But the decision itself and the language that the Supreme Court issued, and this was a question that came up from Representative McCarthy, was who gets to decide what's reasonable? Or how do you decide what's reasonable? Right? We look at certain things in that. And in that court case, it laid out kind of a three-prong test, or what we call a four-prong test in Vermont for that reasonableness. And we're looking at specific things such as what was the severity of the crime? Was that person that we're using force against committing some crime that we needed to intervene on or that we had to take them into custody for? Is it a $5 retail theft that we can find a person later and issue them a citation for? Or is this an aggravated assault or a domestic assault or an attempted homicide? That severity is going to be much different for us to get involved with. Second thing would be whether or not that subject posed an immediate threat to officers or others. Right? What were their actions at the time? Were they posing some threat? Were they violent acting? Were they making threats towards violence? Were they posturing and demonstrating verbal cues or nonverbal cues? They were going to assault somebody, hurt somebody, fight with somebody. That immediate threat. Whether they're actively resisting or trying to evade. When an officer tries to take that person into custody, what is their action at that time? Are they compliant with us? Are they listening to us and obeying our commands? Or are they trying to get away? Are they trying to evade, trying to resist the actions taken by that officer? And then, as it talks about on the policy and the legislation, is were those circumstances that the officer faced tense, uncertain, rapidly evolving, and dynamic? And that comes back to that calculus that officers have to make split-second decisions, sometimes with limited or little to no information at the time. And that's really looking at a case, looking at something. Those would be the questions that, as a supervisor, as a reviewer of a use of force report, those are the things I look at and the questions I want answered when I'm looking at that report to determine if that force was reasonable. Why were we there? What was the severity of the crime? What were we doing? what was the subject doing? Were they a threat to other people? Were they resisting, trying to evade, trying to assault the officer, trying to assault somebody else? And then how fast did this all happen? Was it a matter of 20 minutes where we could sit down and talk about it and interview somebody and deal with the situation? Or was it rapid fire as soon as the officer got out of the car, this was happening in front of them and they had to stop that action?
And those factors are laid out as well in the policy.
It was laid out in policy language, was it laid out? Yeah, they're in that policy language and in the case, the Supreme Court case itself.
Yeah, let me just ask one more question since I've already interrupted your.
That's okay.
When you're talking about necessary, you said something along the lines of to be in whether the officer should have been there or been involved in the first place. Can you expand on that a little bit? Does that mean, well, I'll throw out an example. An example, I guess it was in Cleveland when the law enforcement, they drove right up to somebody. It was a young male who had a toy gun. And the thing is, they drove right up to the person and jumped out of the car. And that seemed to be a situation where they may not have wanted to be involved in the first place. But that's just the example that comes to my mind. But can you expand on that as far as?
And a situation like that is something that we do consider and that we do look at when we're examining that use of force. Did the officer's action put them in a position or put them in a place where they may have created that immediacy or created that exigency? Were there other tactics? Were there other things that they could have done? Parking farther away, setting up a perimeter, standing behind a piece of cover, something like that, to give themselves more time to deal with that situation, examine that situation and gather more information? Or yes, did something they did exacerbate that, I guess, for lack of a better word? Did they create that emergency or that exigency? That is a factor that we would definitely consider reviewing a use of force. And that would be that necessary thing. The other part would be, do we have other options for dealing with that call or that complaint? When we look at the appendix, it talks about dealing with people experiencing a mental health crisis. Most agencies now have some ability to contact a mental health crisis team or a mental health clinician or an embedded social worker or mental health worker for their agency. And maybe that is the more appropriate resource for that call or that complaint versus an armed police officer to be there for that complaint. And those would be other things that we would look at when we talk about that necessary standard.
Thank you. Representative Brandon.
And my questions are along the same line. It just seems to me like it must be extremely difficult for the officer to imagine or to concoct what he thinks someone else is going to do, and then have his own actions intervene with what the person is doing now to what he's going to do in the future. And how does he know, even 10 seconds down the road, what somebody's going to do?
And we don't know. And then that's the big question that's out there. And it's when we talk about this, those four factors that we talked about, examining what's reasonable in use of force confrontation, it's not a one-time evaluation. It's not I get the call from dispatch, I respond to the call, and this is what I'm deciding on the way, and this is what I'm going to do. It is a continuous and ongoing evaluation depending on what that subject is giving us for a reaction to just our presence sometimes, or maybe the orders or the commands that we're giving them or how we're speaking to them, and then are we getting any resistance from that person? It's constantly changing, constantly reacting, and the officers have to be able to articulate their perceptions at the time. What did they think was going to happen? What did they think that person was going to do based on their actions and the way they were speaking, the verbal cues they were giving us, the nonverbal cues they were giving us? Are they tensing up? Are they posturing? Are they turning towards us, turning away from us? All those little things. It is a lot of information to put together in a very short amount of time to start making some of these decisions, but that is part of our training and part of what we do. Again, the physical skills are the easy part. When we start to train this with officers, it relies heavily on scenario-based training where we can put them in a situation with a role player that's exhibiting some of these behaviors so they can see this and experience it and start to make those decisions on their own and formulate those plans on their own based on what they're seeing and what they're reacting to.
And I can see where an officer who has 15 to 20 years experience, he would probably be pretty good at that. Mm-hmm. But somebody this morning testified to us that they're hiring kids who have no training because of the unemployment situation. Right. I just see lots of potential out there for misaction, abuse maybe.
And that's where we have to rely on our training to teach them the right way to do this and hopefully give them the tools that they need to be able to make those decisions and, or at least open their eyes to the fact that, geez, maybe I'm not ready for this yet. And maybe they wait or maybe they seek another career path at that point. The training program is not designed to wash people out, but if nothing else, it's designed to open some eyes, hopefully, and get folks to make those decisions. And that is another part of that Graham case when you're looking at those standards that talks about not using 20/20 hindsight to judge what that officer knew at the time. It's based on the information they knew. And the other courts have gone so far as to say it's based on a reasonable officer, but it's based on a reasonable officer with similar training and experience. That does play a huge part in it. An officer that has 10, 12, 15 years of experience in a busy area where they've handled lots of calls and had lots of interactions is going to have different experiences and different background knowledge than someone that is brand new that hasn't ever done this before. So that's where we rely on, again, our training at the academy and then agencies to provide that field training when officers get out to pair them up with an experienced officer to kind of show them how to do this for real now. Now you have that foundational training. This is how you apply it in real time.
I appreciate your, thank you.
Thank you. I'll continue on, and I should have led with this as Attorney McManus did. This is, again, I know this is just designed to be an overview. I can talk for quite a while, as I'm sure you're already starting to gather about this stuff. So I'll keep it very basic, but certainly as questions come up, please ask, and I can dive in depth on anything that you want to talk about. I think I touched on most of that. So when we talk about how officers decide to use force, we generally speak about it as a use of force continuum, right? We look at this continuum and all these levels of resistance that we may find. And this is in the policy and some of those definition pages that talks about it. When we're dealing with a subject, they can present to us in several different ways. The basic, the number one step and the one we hope for most of the time is compliance, right? That person is going to listen to us, going to do what we ask. We're able to end that encounter without using physical force if we need to, or if we do, it's that very low level. We give them orders, they comply with what we do, and we take them into custody, and that's the end of it. We deal with passive resistance, kind of at our next step is where someone doesn't want to do what we're asking them to do, but they're not employing any means to keep us from doing our job. They're not resisting, pulling away, running away, doing anything like that, trying to evade that passive resistance. If you think of a peaceful protester sitting on the front steps and we tell them to get up and leave because they're trespassing and they say no, they don't get up and leave, but then when we escort them away, they come with us. That is that sort of passive resistance. They're not going to leave until we make them do it, but they're not going to give us a hard time when we do it. The active resistance part of that is really where we spend most of our time in the use of force world, is that large area between I want a person to do something or I'm giving somebody a command and they don't want to do it. And then when I try to make them, they don't want to cooperate with that. They pull away, they turn away, they try to run away. They're not assaulting me or anybody else. They're not turning that energy towards me, but their energy is directed towards getting away or not allowing me to accomplish that goal. Get their arm in a position where I can control them, get their hands to a position where I can apply handcuffs and get them into custody. A variety of different things. That is that active resistance. Active resistance can also come out just as verbal resistance. Somebody telling us, giving us threats. You know, you're not going to take me. I hope you brought more than you. I'm not going without a fight, that sort of thing. That is definitely an active resistance scenario and will change the way an officer approaches that situation. We don't, and the policy doesn't suggest it, and we don't suggest it in our training. We don't mean to put officers in a position where they have to be in danger. We don't want an officer to think that they have to be assaulted before they can defend themselves, that they have to take a punch, take a strike, get hurt, get injured before they can react back to that. If somebody says, I'm not going with you without a fight, that's enough for me to determine, okay, I'm either going to get more officers there, change my tactics, use a different tool if I need to, and escalate that use of force to a level where that person is now going to comply with me and do what I want them to. I don't have to go, all right, and kind of duck my head and wade in and hope that I can take a couple shots before I get them under control. That would be foolishness, and that's just how we're going to get everybody hurt. So there is a part of that training which allows for that. If officers can articulate those verbal response cues and those nonverbal response cues that someone's going to be assaultive, and that counts for that, right? That high level active resistance. Beyond that, resistance is where we get into that aggression, that assaultive aggression, where somebody has now, their energy is not turned towards getting away from us or resisting us. It is now turned back towards the officer, fighting with the officer, trying to hurt that officer, maybe to stop them from taking him into custody or doing what they want, or just to plain out assault the officer. That we see that nationwide happening, where officers become targets of things. So that assaultive aggression is any action that person is taking where they could cause harm to another person or to the officer. So that's really what that high level of force that we're looking at there, resistance that we're looking at. And then beyond assaultive aggression, we resort to deadly aggression, or what we call lethal force, where that person's actions are so severe that the outcome of whatever they're doing could be a lethal injury to the officer or somebody else, or at least a long sustaining, permanent type injury. So those are kind of those levels of resistance and levels of response that officers have to consider and think about. And that's really how to kind of put it into words, that's what it looks like in there. That is defined in policy as well. When we talk about de-escalation in relation to police work, I think on page 5 of the policy, it talks about de-escalation, as Attorney McManus referenced. Well, really, it's de-escalation. Initially, when we first told police officers, well, we're doing de-escalation now, you get a lot of eyes roll, rumbles, because everybody thinks that we're not going to do our job and we're just going to stand in the corner with our hands folded and talk to somebody. And that is part of it, is allowing time for a situation to resolve when we have that ability to. Using tactics that allow us to use that time, creating a perimeter, calling more officers to a scene, even though it might not seem like it could be a de-escalation tactic, right? In a one-on-one confrontation, I may have to use a lot of force to control somebody, but with a second or third or fourth officer there, that subject may decide that they don't want to try to fight for police officers, or it may give me that ability to contain that situation a little more, to where we have more time now to speak with that person, use verbal skills, use negotiation skills, contact those other resources that we need to control that situation, versus one-on-one having to charge in and physically deal with that person. So that's where de-escalation kind of fits into police work. It also fits into, like I talked about before, it's that constant ongoing evaluation of what is that subject's response to what we're doing. Are they actively resisting, and then when I put my hands on them, they turn towards aggression, or do they comply? As soon as I use a physical technique on them, they stop what they're doing and they comply. My force is then de-escalating, just because I started down that high level path of maybe using striking techniques or aggressive control holds. If they comply, I'm able to use a lower level of force to control them. And that's ultimately our goal. So that's really what that looks like for us. We have a litany of techniques that we teach our recruits and teach our new police officers coming out there to control people, from joint locks to control holds to takedown maneuvers, different various handcuffing techniques. At the academy level, they get trained in chemical sprays, so pepper spray, and they get trained in impact weapons, so a police baton, which they can use for striking and blocking, as well as some control holds that we also teach them. Other tools they can get, and they all have access to taser training post the academy, if their agency is an agency that employs those tools, and various other tools that are out there. There's various other impact devices and other control tools that are available to police officers. Some agencies have them and some don't. But we do provide all that training to our officers out there. And everybody gets training with calls involving people experiencing mental health crises. As we see more and more of those calls in action, that is really where this policy was steered toward. A lot of what we did was to allow officers to be able to slow things down, set that perimeter, deal with a situation from a distance, from afar, maybe sometimes even over the phone. If we don't need to show up on that person's doorstep, we can talk to them, put them in touch with the correct resources. And part of what this use of force policy and this legislation did was provide for some agencies in some areas to get the resources they might not have had before. Mental health counseling services and crisis emergency workers and embedded workers. That really has been a great step that has come out of a lot of this legislation, was for agencies to have those resources for those types of calls that maybe the police aren't the best problem solver for. Briefly, to touch on lethal use of force, as Ledge Council talked about, we do have in use of force, obviously that deadly force, that lethal use of force portion is something that we still train officers in, a very high liability area for us. Not something that gets used a lot, certainly in our state, which is a good thing, fortunately. But we still talk about that, and it still falls under a lot of the same tenets. The same justification would be required for using use of force, deadly force, as it would be for any use of force tactic. Of that four-pronged test, right? Why do we need to employ deadly force upon this person? What were their actions? What were they trying to do? Were they assaulting us, assaulting somebody else? Was the consequence of their action going to be some sort of mortal injury to somebody else? And we needed to stop that. So that's really what we're looking at there. The policy provided for some prohibitions, which again, most agencies had in place in their policies as far as the use of firearms. There's warning shots have not ever been a thing as long as I've been a police officer. The old movie adage of firing the shotgun in the air to break up the bar fight. Nobody does that. We don't do that sort of stuff, but no warning shots anywhere. When firearms are used, they're used for one purpose, and it's to incapacitate that person to stop that action that they're taking or stop that attack. Moving vehicles and things like that, shooting from or shooting at moving vehicles is a prohibition. Shooting from moving vehicles absolutely is not something that anybody ever did. Again, that's movie stuff, TV stuff, but shooting at moving vehicles has been an issue that we've seen come up a few times. And again, it falls back to is that officer putting themselves in a situation where they're creating that exigency of that lethal force. Am I standing in front of a vehicle that's driving towards me? If I have time to stake a shooting stance and draw my weapon and produce an aimed shot at that vehicle, probably have a chance to step out of the way, which is a much better option. I'm not going to stop a car with a handgun. So it's really where a lot of the training focused on that, and most of the policies were in line with that anyway. And it really comes back to making sure the officers aren't putting themselves by their tactics or by their decision-making in a position where they have to use that force to rise to that level there. When we talk about training, I touched on it a little bit earlier on, training for the academy. So we all have the annual training and certification requirements. Again, the VCJC now requires 4 hours of continued use of force training by agency. That can look like a lot of things. It gives agencies some leeway as to what they want to train or how they want to train it, but it all has to be within our current curriculum of training. So we have our entire program. That 4 hours has to be something that comes from that training curriculum. It can include a policy review. It can include some classroom blocks on just what we're talking about today, that reasonable application of force and things like that. But we recommend it should also include some physical skills. This is a high liability area and probably one of the things officers do most. Of all the gear that a patrol officer carries on them when they're on duty, their handcuffs are probably the thing that they use the most. So having training in that was very important to us, and we're able to get that out there. On top of it being from our curriculum, the rule also specifies that it has to be training that's provided by a current VCJC certified instructor. So when we do our instructor courses, we're putting out the same information again. You may get this information as a recruit in the basic academy, and then if your agency sends you back to be an instructor, you're getting the same information again in an instructor school so that you have that better understanding of it. You're starting to become that agency's subject matter expert in the use of force, and that's really what we want out there. And that way we also have some control of making sure that there's consistent information and a consistent message being pushed out to these agencies that are on the street, that every police officer is getting that training. When we talk about other training, it talks about it in the standard. Agencies are allowed to provide other training to their officers as long as that training is vetted and the training criteria meets the same standards that we have already in place. It doesn't necessarily have to be specifically a council-approved training, but what their training has to be at the same standard as what Vermont expects, what the law expects, and what the policy expects now. And so it's up to agency heads to vet that training that they're sending their officers to or allowing their officers to host to make sure that it's within those same standards.
That's just a quick question about that. So that's only if it's going to be counting towards the 4 hours, but you wouldn't be able to prevent an agency to send somebody to a training that the council might not approve.
Correct.
They just aren't going to count it.
Correct. So that 4 hours of training has to be something out of our curriculum. Right. And in order to make a curriculum change, that would have to go through training advisory committee, through the council, and be put into place there. An agency can pick a class if they want to send people to become an instructor in a ground combatives class from another service that's out there. They can do that as long as the techniques that they're training and the things that they're bringing back to their agency are still within that policy, still meet that same standard of training that we have. We're not training chokeholds. It's still within that same continuum of force of when we can do things, when we can't do things, because standards are different throughout the country. So we just have to make sure that when that training comes back, that somebody has vetted that training within the agency and are making sure that their officers aren't getting things that are allowed somewhere else that maybe we don't allow in Vermont as our standard. But yeah, agencies are free to send officers to public training as they choose. We recommend an annual review and policy review when things happen there. And certainly anytime a policy update comes out, it's a good idea for agencies to train that with their officers, and definitely push that out and recommend it. As far as reporting procedures, and I think, Mr. Chair, you had asked about this earlier. So when a use of force report is filled out, anytime an officer does anything beyond what we call compliant handcuffing, which is simply a verbal order to position that person with their hands behind their back, and I put handcuffs on them, that would be compliant handcuffing. Anything above that, anything that requires me to do any more than that, would trigger a use of force report, which is a separate report from maybe their investigative report or their incident report or an affidavit that would go to court. A use of force report in the policy, it spells out what has to be contained in that use of force report. It doesn't necessarily give us a standardized format for that. It's not something that we got in the policy, which we were hoping for, but it does at least spell out what information has to be contained in there. Those reports do go to the agency, but they are not automatically sent through to the council. The only report that gets sent to the council would be a separate report that we do anytime a CEW, a taser, is used on scene, and that is for even a brandishing of that taser, drawing the weapon and pointing it at somebody would trigger that report. Those reports are then sent to the council, and that data is compiled for annual statistics there. But general use of force reports for everything else are not something that the council currently compiles or currently takes a copy of.
Good question. Is that a legislative requirement for the taser?
Yes.
Use of force?
I believe that came out of the taser legislation when that hit the books and I couldn't quote you the year on that, but it was a while ago now.
Yeah, that may be something we'll look into, but also want to make sure that the council has the capacity if we did.
That would be, yeah, there would be a lot of reviewing to be done, I think. But that reporting procedure and the way most agencies do that, to answer some of the questions that came up before, is so those reports are compiled and prepared by the officer that used that force, whatever that may be. If there's multiple officers there may be multiple reports, or there may be a main report with supplementals attached to that. I can speak from my agency, that would then go to a supervisor. That supervisor, in our agency, everybody's sworn personnel, so those supervisors would be sworn personnel, but they don't have to be a use of force instructor or have any special knowledge on use of force. Most places recommend that, or at the very least, before I was a supervisor and I was an instructor, I would get questions from time to time from the supervisors, say, hey, can you come take a look at this with me? I have a few questions, explain this to me, and make that work that way. Most agencies send that through to at least that immediate supervisor, that first line supervisor of that officer, to review that report. Again, looking at those things, severity of the crime, the reasonableness, and judging what that officer did and why they were there, and all those things we talked about. If that report is deemed to be reasonable and that the force used was acceptable in that case, then that report typically is signed off. Sometimes that's where it ends. Sometimes it goes to another level of supervision if the agency has that. I know my agency, it goes to our first line supervisors, our sergeants. We approve that report. And once I've approved that report, it then goes to the lieutenant in the administrative part of our agency. I say, I approved this report without concern. Here it is for you. They can look at it, nod their head if they agree, and initial on the bottom, and that's the end of that report. If they have a concern, or if I have a concern, that then goes to that lieutenant to see, is it a documentation issue? Is it a training issue? Or is this a legitimate concern? And if it is, that would probably trigger an internal investigation on our part to investigate that complaint. So that would be from the supervisor review to trigger that.
So the report, it's presumably self-reported as well, though, right? Or is there, if there was another officer or witnesses, do they ever get involved in that report or?
Other officers?
Report?
Yeah, other officers could. They would be completing a supplemental report in addition to that. If there was myself and another officer that used force on a call, I would complete a report. They might complete a supplemental report, and both of those are filed together. If the other officer had concern, they could certainly run that up through the chain of command and initiate an investigation or a report on that. If as a supervisor I have concern, we have other things, we're gonna look for those other reports. We're gonna look for the other officers that are there. That would be part of that either administrative review or internal investigation of that report. If there's anything at all that was concerning on that, part of the review process may be watching the video, either the video from the patrol car or the body worn camera video, to make sure that what the officer wrote aligns with what we see on the video. And that there isn't parts that were, either intentionally or unintentionally left out or forgotten about, which could happen. But that could be part of that review. And in a serious use of force incident where maybe a lot of things were done or some injury was received, we would certainly review it in that type of depth.
So if there's any kind of injury or complaint or anything like that, then body camera or vehicle.
Yeah, I would say just from a, due diligence of the review process, if it rose to the level where somebody was injured, the officer injury, the suspect injury, anything like that, the review of that incident would be probably more in depth than it would be of, I had to arrest this person, I had to put him on the ground and put him in handcuffs, and that was the end of it. No injury, no complaint, no anything. I would read the report and go, okay, that probably sounds reasonable, and go with it from there, versus somebody went to the hospital, somebody had to call an ambulance, somebody claimed a report. We would look at that. So that is a way to trigger further investigation of that report. And then, like you just spoke about, another way would certainly be any sort of citizen complaint where the subject of that arrest came in and made a complaint, or another witness or somebody came in and said, hey, I don't think this was right. This is what happened, and this is a complaint I want to make. I think that officer used excessive force, and we would absolutely review that complaint, review all that documentation, and that may get taken to a further step.
Yes. Just some follow-up questions around the supervisor piece of it. I'm wondering if you can share, because I think we, in the previous testimony, confirmed that it isn't necessarily, it's unclear if the person needs to be certified or not, the supervisor. In my opinion, it seems like they need to be certified because there's a lot to be considering. I'm curious if you could say, in your opinion or thought, like, how important is it that that supervisor is certified? Especially if they're the only supervisor in an office.
Correct. And then that's where you would run into the issue of a smaller agency or an agency where it only has one layer of supervision, patrol officers and a chief, and everything has to cycle through that chief. Yeah, that would be very important for somebody to have some understanding of this report. We're not checking it just for completion to make sure all the boxes are checked and spelling errors and grammar errors and things like that. We have to look at it from that standpoint of, was this a reasonable use of force? And you have to have some understanding beyond that. It's a recommendation for most places, and we make it in our instructor school that the instructors are the ones that review those force reports, because they're the ones that maybe have a little bit better understanding of that. Again, that agency subject matter expert, but it's not a requirement in that.
And then you mentioned that there was an initial round of training when this policy was first implemented to supervisors. But let's go over what this supervisor review process, right. Is that an annual training?
It is not.
Okay.
So the policy is, our recommendation again is that agencies review this policy on an annual basis.
Yep.
And review any updates that come out of that. But it is not a requirement there's not a separate requirement for supervisors to review the policy or review contents of this, or how to have training on how to review force reports.
Okay. That seems like that could be an opportunity, because as you're describing it, it's a continuous learning. Like you're learning every time you review one of these. It's an opportunity to think, oh, how could you consider? How would you look at that?
Absolutely.
Okay, that's helpful. The other thing I'm trying to, well, maybe I'll wait on that. Maybe maybe it was the person who before I just, I should have asked, but like so say there's a report that is filed and it is deemed, okay, this was excessive use of force. So then it goes to the council.
Correct.
What are the actions that can be taken at the council level?
They could, and I'm not 100% on this, I'll speak to it as best as I can, but the council could absolutely do their own investigation. They would look into that. It would go in front of what we call Act 56, which is the certification board of the council down there. And they would look at what kind of violation is this? Is this just a force violation, or does this reach the level of a criminal violation? Is there a charge in there somewhere? And if it's a criminal violation, is that going to result in some sort of decertification of that officer? And that would then trigger that whole process of investigation at the council level.
Okay. So it doesn't have to be a decertification. Does it disqualify somebody's ability to review use of force incidents?
I don't believe so.
If they have a pen, if they, no, there's nothing in that.
So, and I think that would be agency specific as far as who the agency chooses to be those reviewers of those reports.
And we can dig into that a little bit more this afternoon as well.
But yeah, Deputy Director Burkell would be able to speak more to that process at the council level.
So I assume that those use of force reports can be used, I mean, not as much it could be used for further education as Representative Bill already suggested. Do you use any of those use of force reports that come your way to modify or to inform the training that you're doing?
Absolutely. At our agency level, we base our annual training off a lot of what we see there. And that's something I've always liked to review is before we're doing annual training for the year. And our agency has been fortunate that they allow us to do use of force training every year. Prior to the ruling, when they said we had to, we were always able to. And we would look at what sort of calls or what sort of circumstances were our officers getting into and maybe try to mirror some of those calls in a scenario-based role-playing type training, see how others would react or to prepare people for those type of calls, or look at what worked and what didn't work. If a variety of officers are having a problem with a specific technique or a specific tactic, we'll look at that and say, well, maybe this works, maybe it doesn't, or maybe it's a training issue where, gosh, we haven't reviewed this in a few years. And maybe we need to spend some time talking about this and practicing this in a controlled, broken down type of environment on the mats and just practice it with each other for a while so that when that field application hits, they've got that foundational skill set back up to where it needs to be.
So you also, you talked a little bit about this, but if you could expand, with respect to de-escalation, maybe it wasn't you as our previous witness, the de-escalation of the officer.
Yes.
And training for how they're going into a situation or maybe escalating their. Right.
We do spend time, especially at the basic recruit level, talking about self-regulation in these situations, how it's easy to take things personally. It's easy to let your emotions, maybe your ego a little bit kind of drive the way we're doing things. And that as police officers, we can't allow to do that. This is a profession, this is a business for us, and that's how we have to view things, and that we can't take these words or physical attacks personally. It's something that we have to regulate ourselves and make sure we're not the one aggravating that situation. The commands that we're giving, the way we're speaking to somebody, how we're interacting with somebody, those verbal and nonverbal cues that I'm putting out as a police officer, is that making that problem worse for that person? It happens all the time where one officer can talk to somebody great and the other officer just can't for whatever reason. And so being able to recognize that maybe I'm not the person today that the subject wants to deal with, but it's Officer B is going to come in and they can talk to them. Being able to recognize that. And some of that also comes back to, we talk about this when we talk about duty to intervene, where it's, yes, if you see somebody using excessive force or assaulting a prisoner or doing something that extreme, you have a duty to intervene. But we also talk about it as watching your fellow officers, watching that partner officer that you're there with. And if I see that officer getting to the point where they're getting aggravated, they're getting frustrated, their response to the situation is becoming worse, that's my job to step in and kind of, we call it just tagging out, just saying, hey, I'll take this one from here. Why don't you step outside for a minute and deal with that situation and try to get things back to where they were or get things calmed back down. If we recognize that that's not working for that person, maybe somebody else is a better choice. And to not take those things personally, not deal with it as an affront to your skill level or your ability or your, anything at all. It's just business and it's just the way it happens. So we do spend a lot of time talking about that and dealing with that, and that this is your job, this is your profession, and you have to be able to turn off some of those personal indicators, which is a difficult thing when people are calling you names and swearing at you and doing all sorts of things, but it has to be part of our training. It has to be part of what we do, and that's what sets that profession different from normal interactions on the street.
Appreciate it. I don't know if you had more of any other questions?
I have a quick one. So we've talked a lot with you and Ms. McManus about
the obligation for specific agencies to adopt the policy. Do you do any specific training for agency heads at the Criminal Justice Council?
I do not, other than that initial round of rollouts when the new policy came out in 2021, we've done no more.
I guess what I'm getting at is there any specific obligation that comes from the policy or just by virtue of being a sworn officer for an agency head in particular to, promote and follow that policy? Or are they basically, in the eyes of the Criminal Justice Council and the policy, just another law enforcement officer?
The policy is there, and I think, the agency head, ultimately, that responsibility lies on their shoulders for what their agency is doing, the policy that they're following, knowing that this model policy is out there and that this has to be part of their general orders or rules and regulations or whatever they have. It is their responsibility to make sure that they're doing the right thing and that policy is out there. But yeah, aside from a separate audit of their training or audit of their records, I don't believe there's any follow-up that is going to be a double check on that.
I guess what I'm getting at is something that I continue to wrestle with. I've done it sitting in this room quite a bit, is that we have a lot of agency heads that serve at the pleasure of a municipal government, the legislative body like a select board or city council. We have agency heads who obviously serve at the pleasure of the governor and work for the executive branch. And then we have elected agency heads in 14 counties. And that the levels of accountability for those two types of law enforcement agency leaders are very different. But there isn't anything in the use of force training or policy that makes a distinction, I guess is.
No, be the same with the certifications issued by the council, right? If you're a certified law enforcement officer in the state of Vermont, that is a single certification that every one of us has. There's those different levels within that certification process, whether you're a level 3 officer, a level 2 officer, or a level 1, but that certification is the same. And the responsibility is the same. And it really, not to go too far down the rabbit hole here, but it comes back to kind of the core tenet of what we do as law enforcement officers. It's based on our integrity and the fact that people believe we tell the truth. When I write an affidavit and send it to the court is recognizing that what I put in that affidavit is the truth. I'm swearing that that is the truth that I put in there. And so that integrity is kind of one of the core values of being a law enforcement officer in this state and anywhere else. And if you can't maintain that, or an agency head can't maintain that with their employees or even with themselves, and that would call into question everything they do. And that's really kind of what it comes down to, is that, yeah, there may not be anything specific in that policy that says we have to follow this, but that's the policy that's issued. And if I want to be a good agency head and I want to run my department the correct way, I'm going to follow that policy because that's the right thing to do. It sounds a little cheesy, but that's really what it boils down to.
It seems to boil down to common sense, and yet here we are. Thank you very much, Sergeant.
Thank you very much. Yeah, thank you very much, Sergeant. I really appreciate it. It's been very helpful. It's very illuminating. Great.
Thank you.
So we will adjourn until 1, and we have Deputy Rickle here on enforcement. After that, I have probably a fairly brief executive session.